Hi everyone, I'm seeing people coming in. We're so glad that you're here. My name is Martha Osterbiel. I'm the Community Engagement Manager at the Maryland Center for History and Culture. And I'm part of the center's public programming team who's working to provide free virtual programming and professional development webinars like this one. Though Maryland's 2020 legislative session was cut short by the beginning of the COVID-19 pandemic, the state's museum community won a major victory with the passage of Senate Bill 88, governing the stuff of a museum registrar's nightmares, abandoned cultural property. Thanks to the support of Senator Antonio Hayes, Delegate John Cardin, and other leaders in the legislature, the Maryland Center for History and Culture, formerly the Maryland Historical Society, was able to rally statewide support for the Abandoned Property in Possession of a Museum bill, addressing the significant, if little known, burden for museums in Maryland. We're really glad to see folks joining us from all over the state to learn more about this new legislation and what it means for your collection. If you'd like, please introduce yourself and let everyone know where you're tuning in from and what organization or collection you're representing by utilizing the chat feature. And just be sure that you're sending your message to all panelists and attendees if you'd like to engage with the entire group. We'll be leaving a substantial amount of time to answer your questions at the end of the program. Please type them into the Q&A box located at the bottom of your Zoom screen. This program is being recorded and will be made available to rewatch and share with your colleagues in the coming weeks. We'll provide that recording in a follow-up email, which will include some other helpful resources discussed in today's program. So now it's my pleasure to introduce our guests. Katherine C. Grier is Professor Emerita at the Department of History at the University of Delaware and the recently retired director of the Museum Studies Program. She originated and shepherded the Delaware Abandoned Cultural Property Initiative, resulting in the bill that was signed in March 2017. She is the president of the Delaware Museum Association, and we're so glad to have her insight on the Delaware Museum's experience with their law's rollout. Welcome, Casey.
Thank you very much. I'm glad to be here.
Paul Cucuzzella is an Assistant Attorney General with Maryland's Office of the Attorney General and serves as counsel to the Maryland Department of Planning and Maryland Historical Trust, a position he's held since 2013. From 2002 to 2013, he served as Assistant Attorney General and Senior Counsel for Litigation to the Maryland Department of Natural Resources. Mr. Cucuzzella is also an active member of the U.S. Army Reserve, Judge Advocate General's Corps, serving in the rank of Colonel. Welcome, Paul.
Thank you for having me.
Last but not least, Allison Tolman oversees the museum and library collections at the Maryland Center for History and Culture and is responsible for the preservation, research, access, and maintenance of these collections. Allison also leads the development of dynamic interdepartmental exhibition teams, both in person and online. And her favorite part of working at MCHC has been developing, preserving, and using the fashion archives to create personal connections to history. Welcome, Allie.
Thanks, Martha.
So we're going to get started, and I'd like to turn it over to Paul. Can you please provide us with an overview of the new legislation and what it means for Maryland cultural institutions in possession of abandoned cultural property?
Sure. So coming into the 2020 session of the General Assembly, Maryland was one of only a handful of states who didn't have a written into law, written into statute, a mechanism by which museums and cultural institutions can dispose of or otherwise clear title to property for which the records of the institution can't properly document ownership. And so inspired by what Delaware did a couple years ago, a bill was introduced in 2019 that didn't make it through. And then again, the bill was introduced in 2020. It was Senate Bill 88 and House Bill 21. They were cross-filed. And as of, they passed and signed into law by the governor, and as of October 1st, this law is now codified in the commercial law article of the Maryland Code in Title 17, Subtitle 4. And what it does is, as I said, it provides a mechanism by which museums and cultural institutions can sort of take care of those problem pieces of property in their collections for which they can't document clear ownership. And the statute identifies 3 classifications of property that this works for. So the first is loaned property. So property that's actually been loaned to the institution, whether it be under a loan agreement, a written loan agreement, or it could be a handshake agreement. But in some fashion or another, the property's been loaned. It's loaned for either an indefinite period of time, or it's in the possession of the museum after the term of the loan has expired. So in other words, it's property in the possession of the institution that is sort of beyond the bounds of a loan agreement at this point. The second type of property is undocumented property. What that means is property in the possession of the institution for which the records of the institution don't reflect where it came from, ownership, how it got the property. So it's just property that's there that the institution doesn't quite know who the owner is or how it got it. And then the third classification of property is what's called unsolicited donations. So this is property that's been left with the institution. It hasn't been solicited. It wasn't asked for. I think some examples I've heard in the past are these are like door drop sort of property where someone just sort of leaves the property because they think the institution will do a better job of curating it than the individual. So these are the 3 groups, the 3 buckets of property for which this statute works, and the statute provides a mechanism by which the institution can clear title to these classifications of property on an individualized basis. So, and the procedures are different for each, so I'll just sort of walk through them. For loaned property, notice has to be given to the lender. So whomever the institution got the property from on loan, they have to provide written notice to the lender that they intend to clear title to the property. And the statute provides a list of things that have to be included in the written notice, including the name of the lender if known, the last known address of the lender if known, a description of the property, what's the institution trying to clear title to, the date of the loan if that's known, the name of the institution obviously, and then a point of contact for the lender to get in touch with the institution if they perhaps don't consent to the transfer of title. So this written notice has to be provided by certified mail with proof of receipt, and that proof of receipt has to be received back within 30 days. If after 60 days of that notice having been received by the lender, if the lender doesn't come forward to claim title to the property, then by virtue of the lapse of time of that 60 days, the title to the property is cleared and it's now owned by the institution. And the key here for institutions is to well document this process because what's not going to happen is there's not going to be any sort of court order, and this doesn't get recorded in the land records or anything like this. The existence of the transfer of title will really reside only with the institution. So the institution needs to document the certified letter, the return receipt, and then at the end of that 60-day period, it's probably a good idea for the institution to then include it in their file on this property, some sort of memorandum that states that they complied with the statute and that they claim ownership to the property. So that's loaned property. The next category of property is undocumented property, and for the process to apply to this property, the property has to have been in the possession of the institution for at least 3 years, and here, obviously, since it's undocumented, they don't know where it came from. The institution won't know who a lender is. The institution won't know who the prior owner is, just by virtue of it fitting into this category of property. So the notice is by publication, and what that means is all that same information that is in the statute with respect to what information needs to be provided to a lender. In the case of a loan, in the case of loaned property, needs to be provided in a public announcement, in a newspaper of general jurisdiction within the city or county of the institution, and it has to be published for 2 consecutive weeks, once a week for 2 consecutive weeks, that's notice. That's the notice requirement. And then if after 60 days of that public notice being given, no one comes forward to claim the property, then the title to the property is cleared and it becomes owned by the institution. Again, documentation is important in this instance. The museum should keep good documentation, first reflecting that it's property that's been within the possession of the institution for at least 3 years. The documentation should include the public announcements, the web print off from the newspaper, or a photocopy from the newspaper of the notice, and then some sort of statement in the file after the fact that 60 days had lapsed, no one came forward, and therefore it satisfies the clearing title requirement. And then finally, the unsolicited donations. This is handled similarly to the undocumented property. If it's an unsolicited donation, no time requirement is necessary. You don't have to wait. So if someone drops property off at the doorstep, the next day, the institution can initiate this process if they want to. Again, it's by notice by publication. All that same information is provided in the notice, and then once the 60 days have expired, at that point, this is a little bit different from the other two in that the statute says that at that point the property is considered to be a gift. And which really is a distinction without much of a difference. In the end, it means the institution owns the property. The law says it received the property by gift instead of having title to the property cleared. So those are the 3 processes, or the 3 mechanisms for the 3 different categories of property. So that's sort of the nuts and bolts of what the law does. And when we get to the end here, I'm happy to answer any questions. The last thing that the law does is it provides a measure of certainty for institutions in being able to care for property that's been loaned to it. And so oftentimes an institution will need to provide conservation measures to property that's in its possession that it doesn't have clear title to, that's loaned property. What this new statute does is it says, unless the loan agreement states otherwise, the institution is allowed to provide necessary conservation measures to loaned property, and then whatever cost is incurred by the institution to do that, then establishes a lien on the property in the amount of those costs. And that just provides the museum some assurance that it is doing the right thing, that it's not violating some sort of property rights by applying conservation measures on property it doesn't own. And by law, it's permitted. It's absolutely by right to provide to apply conservation measures to property. Again, but this is in the absence of, say, a loan agreement providing certain conditions. So sometimes a loan agreement will have a provision in it that specifically speaks to conservation. And in that case, the provision of a loan agreement would control what the institution's rights and obligations are. I think I've pretty much covered everything that the law does, unless, Kathy, unless you think something, or I'm sorry, Casey, unless you think otherwise. But I'll hand it over to Casey at this point.
Okay, so I think my task, if I recall correctly, is to give background on the Delaware process and also on some of the situations that inspired the initiative. The Maryland law contains a couple of details that the Delaware law legislation does not. And down the road, I actually think that we might take a look at a couple of those and try to get our bill amended. But first we have to get everybody to use it, which is another story altogether. But this initiated was, one of the things that I did as director of the Museum Studies program was developed a public service project every January where we did collection management for a couple of weeks with small institutions in our region. In fact, we even did one in Maryland, and one of my examples comes from that experience. So we would go to these places and discover, you know, as we were involved in rehousing, doing basic cleaning and starting to get their collection records sorted out, these massive quantities of things for which there was no paper trail. And what would happen was we would, you know, there's a category called found in collection. So we could give them what was called a found in collection number, or some other kind of number that distinguished them down the road, so that at least we had a record from the time that we had appeared on the scene, that this thing had been found and that it had a number, you know, so that there was some kind of documentation on it. But we would often find, you know, things like one place we worked, literally the first or second day we were on the site, a volunteer receptionist had taken in a black plastic bag full of early 20th century women's dresses in beautiful condition. So not only was this it was a doorstep donation, something that was actually desirable, really desirable, but, you know, first of all, so not only was there no title because there was no deposit form or even any way to trace back the owners, but it also means, if you think about it, you may go, oh, well, it doesn't matter so much. Well, interpretively, it also matters because you no longer have provenance. We don't know who wore those dresses. We don't know who made those dresses. So what you're doing when you accept, when something like that happens, is you're sort of shooting yourself in the foot interpretively. And a lot of times people don't think about that. So anyway, we would discover this problem. So as part of my introductory museum studies course, I assigned a group of students to do a policy brief on abandoned cultural property, because we discovered that there was no way in Delaware for us to actually get rid of anything. That these collections were sitting around and there was no clear title. And sometimes people were literally just putting things in the trash, which I also don't advise. But you know, there was no way to dispose of them in a good way. And if we worked on storing them properly and caring for them, there was money going into caring for these collections. What oftentimes folks, especially in small museums, don't think about is that there is sort of a unit cost for bringing in a collection item, and they cost money, right? They're part of your shelving, your supplies, your utilities, your time, which is often not measured, but collections actually cost you money. So we produced a policy brief, and then at the end of the semester, the students stayed on and we looked for a legislative sponsor and found a sponsor who was willing to work with us on, who had a master's degree in history. So first of all, he was interested in old stuff. And so we were able to get him to be our legislative sponsor. However, and we met with him multiple times to get the legislation hammered out with one of the staff lawyers. We had picked out, we gave them the whole policy brief, but we had selected the best laws and cited them as where we thought the examples should be for drawing, for writing the Delaware bill. I will say, however, that one of the things we learned pretty quickly was that this legislator, who was a great guy, and his colleagues did not really understand what a museum collection was. They didn't understand the idea of public trust. They didn't understand how collections decisions were made. At one point, we had to put out a fire where somebody had proposed that everything that came in as a doorstop donation needed to be examined by Homeland Security because it might be stolen. And what we had to do was convince them that it was very unlikely that someone had stolen some things, would decide to hide it by donating it to a museum. So we went through a long process of kind of educating people about what a collection was. And I came to the conclusion that this is actually a communication problem for lots of museums, and they really need to think about, you all really need to think about educating people about what a collection actually is and what it means to hold a collection. There really doesn't seem to be a lot of public understanding of that as an idea. So now we have the Delaware law. We were lucky enough to have a big event signing it. The governor wanted to sign it with students, so the students got to participate in this. But now the problem for us is teaching people how to use it. And so one of the reasons I was very happy to participate in this was to get a sense about what you all might be doing or what you all are seeing, because we're going to have to, it's become clear to us over the last year or so that we need to do training. The large institutions have gotten on this and are actively using the abandoned cultural property legislation, but the smaller institutions seem to be stuck. So for us, the next phase on this is training. And you know, some of this training is going to have to be online, but I also think that down the road we may have to do some, when changing circumstances permit, that what we may want to do is some on-site training, taking a look at existing collections and helping people figure out how to assess them. So it also requires that especially all volunteer organizations rethink of themselves in relation to collecting, that it has to become a much more formal process. It's been a friendly process where people drop stuff off or share things, stuff comes in and out for loans for exhibits and stuff, but the long-term consequence of that has been storage rooms full of things that are a financial drag on an institution and that people don't actually have true legal control over. So I'm happy to answer any questions or any thoughts, share any thoughts that you may have on this, but I'm interested to hear what you all have to say on the subject as well.
Thank you, Casey, and thank you, Paul. I was going to show some case studies, but we had 14 questions already. I think that a lot of people have read the bill and have questions very specifically about their institutions. As Paul mentioned, the three areas that we're talking about are permanent loans, those undocumented property or found in collection items, and unsolicited donations or doorstop donations. I could give plenty of examples of each. We've been open since 1844. I have looked back.
Well, you got a lot of them.
Yeah, I think the oldest permanent loan is from the 19th century. We do get a lot of doorstep donations. And one of the things that happens a lot to us is that we will get an unsolicited donation. You know, it'll be dropped off or it comes in the mail with no return address, no information, and it's a non-Maryland object. We don't collect on Maryland objects, but I can't transfer this to another institution and say Pennsylvania if it is something made there because I don't have the title to do that. So this kind of thing does happen often. And of course, found in collection, we have been, our oldest building on our site is from the 1912. So I have things like furniture casters that are very early. And I can't tell you if it's from an exhibit of furniture or if somebody donated furniture casters. So those are our kind of found in collection items that are examples of what we deal with here. Martha, do you want to just take us, we have 15 questions and to answer here. So I think it's most beneficial if we really help everyone who's on the call. We have about 40 different institutions tuning in and everyone has very specific questions. So I really want to give time to that.
Agreed. So I'm just going to start, and Casey, Paul, Allie, whoever feels inclined to answer, please just jump right in. So our first question is, do we need to give notice to heirs of lenders, or do we just have a responsibility to send it to the lender?
So the statute just talks about the lenders. So, you know, the notice requirement is to the lender at the lender's last known address. What I didn't mention up front was you give the notice. In other words, you send the notice with the return receipt. If you don't get the return receipt back, then what happens? If you don't get the return receipt back, then what happens is the notice then defaults to the notice by public. So if the actual trying to reach out and notify a known person or entity fails, then you do notice by publication. That would be, in my mind, that would then be notice to heirs. Mm-hmm. So I'm pretty sure the answer to the question is no.
Okay. And following up with that, this is just a clarification. We talked about making a notice for lenders in publications, and there is some uncertainty about that in the law. And can you just clarify which type of property needs to be advertised in publications one more time?
Of the 3 types.
Yeah, so it would be any undocumented property or any unsolicited donations. And then really the third category is if the notice to a specific person for loaned property is unsuccessful. Mm-hmm. If you don't receive the return receipt within 30 days, then you can clear the title through notice by publication.
Mm-hmm. And along those lines, does each object need its own notice, or can they be bundled?
That's a good question. I would say that it probably depends on which category of property you're talking about. If you're talking about loaned property, then you could probably bundle anything loaned from a specific person or entity, an individual lender. If you're talking about, like say, unsolicited donation, you could list all of your unsolicited donations in a single notice by publication. Let's say you got 15 things on there, and let's say like 3 people come forward claiming 3 of the different things, then all the rest of them you've cleared title to, and maybe you just have to deal with the 3 for which people have come forward.
And does the legislation specify whether or not those public announcements need to be in print or digital?
I'm looking at it now.
I believe it says print.
Okay.
Just reread through this last night. It has to be of a certain circulation, so
Yeah, it's general circulation.
yeah.
Published at least once for 2 weeks in a newspaper of general circulation. So, I mean, most newspapers have a print version and it has to be a circulated newspaper. But most have both a print version and obviously an online version, and whatever the notice is would appear in both places.
Yeah, and in the
Well,
case
it would go into the legal notices, right? There's always a section in, and if you're in a small town and you've got a weekly newspaper or regional weekly newspaper, there is always a legal notices section because they have to handle other kinds of bankruptcies or property disbursement or things like that. So it goes into your legal notices section.
This is an interesting question, and I'm sure that there's some follow-up that might come out of this. But the question is, has the Sun, the Baltimore Sun, been informed of this new legislation? And if so, have any deals been made to work with museums to get these notices out, or any payment or bundled deals? If anybody knows.
So the Sun, we did a press release when the property law came through. And there was an article, but I don't believe it was in the Sun, talking about the abandoned cultural property and what its intention is. So I believe that they are aware of it, at least in that regard. I don't know of any deals to nonprofit institutions. I would assume that they have different rates for nonprofit institutions than commercial institutions, but it's certainly something worth exploring with them. Maybe that's something we can do.
Yeah, definitely. Or at least working, I would think that several organizations on this call could also come together and collaborate and maybe work out a deal.
Right. I believe that in some cases, though, you have to do like where the loan came from. So the Sun may not be helpful if this is a loan from outside of Baltimore.
I'm changing gears a little bit. This is a question for Casey. How did museums deal with funding in regards to getting the notices published? And were the grants were there grants created to help with this in Delaware?
At this point, there is no grant or anything that would help you do that. The Delaware Humanities Council and the Arts Councils support programming. We may try down the road to do something through the Delaware Museum Association, where where we do an organized initiative to help small places, in particular the half of the historical organizations in the state are so small that they only turn in a 990 EZ postcard, right? So these are organizations that are going to need some help with this. To tell you the truth, the legal notices it doesn't cost very much to post those legal notices. The issue is more the buried cost of the processing, right, on the museum side. And again, it's part of that issue where smaller organizations in particular tend to not think about collections as costing anything. And so they, they're actually expending, money, or they're actually in violation of their stewardship requirements by allowing things to deteriorate. So, there's sort of a bigger question about training about what a collection is and what obligations are. And I think that there's, I'm sure it's true in Maryland as well, that there needs to be sort of a broader education about the obligations of stewardship and the costs involved in bringing things into collections. So it's something that we have to investigate. It's been very clear that the small guys are not using the law yet. And so we need to figure out why that is the case.
Right, thank you. Here's a question from Jennifer. She, and this is, interesting with our Delmarva region. She's asking if the parent organization of your museum is in DC, but your museum is located in Maryland, which abandoned property law should be followed?
Wow, that's a good question. I hadn't thought about that. I would think it's the jurisdiction where the property is located.
Mhm. Where that collection resides.
Exactly. Yep. Let's see if there's anything.
Is the parent organization the one who's claiming legal deed? Like if the deed of gift comes from that
Right. Who's on the deed of gift?
organization, that would be the organization who is legally holding title to the entire collection.
Okay, so, okay, now
Gift,
that
like, on the-
looking at the definition section of the statute, this only applies, this bill, Maryland's bill, applies to museums located in the state. So to use Maryland's bill, you have to be a museum in the state, and presumably the property would have to be property located in the state.
Mhm.
I would think.
Thank you. If an unsolicited donation has contact information, do museums still need to follow the mechanism for a loan or for an unsolicited donation?
If you have information, that's great.
Yeah, that's what you want,
that.
right?
You can reach out to them directly and ask their intention. You have a point of contact then. If you don't get a response, then Paul can speak more to this, but if you cannot get a response from that person, then I think you have to go toward that notification. But if you have their information, see if you can contact them and ask if it's a donation.
The first thing that I would do is actually try to do retrospectively a deposit form, right?
Yeah.
I mean,
Temporary,
one of the things,
custody seat is what we call them
yeah,
here.
get a custody, one of the forms that gives you custody, and I would do that, and sort of start the process that way. And then by getting a custody form, if you can do it, if you get a custody form, then you can actually start the process of figuring out whether you want it, you don't want it. You can kind of get around this problem completely. You can put it into your normal, acquisition decision process. So that's what I would do is immediately. The other thing I would advise everybody to do is to have a simple custody form at your front desk, sitting there on a clipboard, and your volunteer receptionist, who's been the one who has been taking in the black plastic trash bags full of wedding dresses and stuff like that. They've got to be trained to not let people do that. And even if that means chasing them into the parking lot, they need to do a deposit form. You need to do a deposit form. If you can get that deposit form, you can get around this entire process because you can immediately start putting it into your normal collection decision process. It should be a very simple form, by the way, so that they, with signatures attached to it. So.
Yeah, as long as you can get that contact information and
that's
that
right.
signature and a line about what they're giving you, that's all we need.
That's all that's needed. That's right.
So this is an interesting question, and Allie and Casey, maybe you can speak to this, but Mariana is asking, if abandoned cultural property is primarily a concern when it comes to deaccessioning, which I think is possibly one of the concerns, but I'd like if one or both of you could embellish on some of the other reasons why it's important to be able to claim title.
Sure.
Do you want to start with that?
I was gonna say, do you want to go first or would you like me to go?
Oh, okay, that's whatever. Well, first of all, and it's already come up in relation to conservation. When something comes into your building, you've got a duty of care, and care costs money, right? Archival boxes cost money, tissue paper costs money, it all costs money. And so, and then if the object needs conservation, if you think you might want to exhibit it, if it wants conservation, it's another reason that you really want to have clear title before you sink money into objects. Because if you've spent a lot of money on conservation or raised money for conservation, and then the object has to be returned to the family, you have spent valuable operating dollars. You have to The reality is that, you know, you have to sort of think about the money behind collections and collections care. Al, you wanna add to
Especially
that?
if that you then return it and that family goes on to sell it and they have an increased
Yep.
profit based on work that was done at the nonprofit institution.
That's right. That's right.
So the reasons that I am very excited about this is that we're open for a very long time, 176 years. I have pieces that are permanent loans that I do not have permission to loan out. We had Maryland would like to use an image of a painting in a textbook, and I do not have the right to give them that image. So I literally can't help education because I don't have the title to a painting that has been in my care since I think that one is like 1895. So we also don't have permission to display or conserve. So if there's an exhibition where it helps with our storytelling, I don't have the title, so I can't loan and expose something to display conditions without permission, nor can I conserve it so that I can display it. So this law helps us use our collection. Basically right now, as Casey said, we are spending money to keep it in a climate controlled storage situation. It's not ours. I can't use it. I can't lend it to other institutions who can use it. I can't conserve it. I just have to hold on to it, eat up storage, and that's it. So this really allows us to better use items that have been in our care for a very long time.
Thank you. I think that's helpful, a helpful way to talk about the importance of this for Maryland institutions and collections. There are a couple questions here about found in collection. So if it is an FIC, an object, and it's an object that the museum would like to keep, would they still proceed with undocumented property terms? And if someone answers, do they still need to prove ownership?
The first part, yes, because claiming title does not mean throwing out.
Right.
Claiming title means saying that you now own the property. For the second part, I'm going to have to rely on Paul.
Yeah, I'm not sure I quite followed the scenario there.
Mm-hmm. So
proof of ownership.
Oh, the entity coming forward.
Mm-hmm.
Okay, so yeah, this bill doesn't provide a disputes mechanism. So yeah. So at that point, that's at that point you have sort of a factual give and take or tug of war. If someone comes forward, you publish notice. Someone comes forward and says it's mine. Well, how do you verify that? Yeah, that's tricky. And as I say, there's no mechanism in this bill to sort of resolve those sort of things. There's no mechanism that says here's the level of proof. You know, if you know, push came to shove, let's say the institution doesn't believe the person, and because their story doesn't make any sense, let's say, you know, the institution could say, no, I don't believe you. I don't think your story makes any sense, and we're not taking your word for it that this was your property. And then that person might, you know, would have the right to challenge that decision and file a lawsuit, you know, claiming unjust, you know, ownership or possession. So that's the way. I mean, ultimately, you know, the courts could work these things out, but yeah, that's a tricky one.
Casey,
I think that. Yeah, I was going to say, Casey, the same thing, because when you talked about assigning those FIC numbers, that is actually could be a really helpful mechanism in that proof of ownership. Like I know we have no number objects or FIC numbers that I can show were moved in 2007. So I have that no number object, that unique ID being moved from one part of storage to the next. So if I put this out and then someone says it was in my house in 2008, it's like, no. Perhaps you have other examples, Casey.
Yeah, we don't have a good dispute mechanism either. I mean, we will have to deal with this. Another thing we'll have to deal with down the road. But I think, again, what I would do is, you need to be strategic about this in the sense that I can think of, there's a couple of categories of objects where you might be possibly get people turning up who are, don't have a direct actual connection to the object. And probably the biggest single category, and we've talked about this, is militaria, because there's a world of these collectors who can be pretty aggressive. And what I would say is that for now, until more, a law is, a living document, is itself a living document. What I would say is don't start with the militaria or your best paintings, right? I mean, although you'd really like to get clear title to those, what I would do is, first of all, get your founding collection paperwork in order. And then what I would do is start with the things that are less likely to be problematic. And get good at using the law. And not only that, but once we have a body of practice in place, it's going to help everybody. We're at a point in the process where there's a lot that we're just not sure how it's going to roll, right? There's a couple of other categories that are problematic. I would say I wouldn't start with your coin collection. I wouldn't start with your militaria, your best paintings. And actually someone pointed out that dolls can be really problematic. So what I would do is start working with the law and use it with some of the categories that are less problematic, right? Anything that has a really high retail value. Another area that can be problematic is silver. So you're going, well, what's left for us to do? Well, there's a lot of, it's a good question. I'd start with some of the areas that are, business memorabilia, furniture. When I worked we had an abandoned cultural property law when I taught in South Carolina that had a very long waiting period attached to it. But what we were able to do was one of the things that it took us 3 years to get rid of some of these things, but we started with wardrobes. Oh my God. I mean, we were drowning in wardrobes because people couldn't install them in their houses anymore. Wardrobes and sideboards are.
Right. Now that closets exist, wardrobes are on their way out.
Yeah, wardrobes are on their way out. So we actually started with some things like that. Because we needed to clear up storage space and they took up a lot of room, and they were not problematic at all. So you've got to be, what I would do is be strategic about starting until we have a body of practice. The other thing is that this is where your local ties to your community need to come in with some of this material. Right, is that if you're a very local institution and you've got old volunteers, old board members, older people who've been around your organization for a long time, before you start this, what I would do is take them through the storeroom and say, these are a problem. Do you know anything about this? They may have been the person that took it in, right? So, we've got a legal process in place, but you have to use sort of a human process to get
institutional memory is one of the
institutional memory really counts on this. Yeah.
I think that's great advice for a lot of organizations who are tuning in today. Thanks, Casey.
Oh, you're welcome.
I'm going to try and answer a few more questions. We're nearing the 1 o'clock hour, but I know that this is all new and this is a valuable webinar, I'm hoping. So another question here about the public notice. Kay is wondering what to do if the lender's last address is not local. So, they're not going to see that distributed publication potentially.
Yeah, so the requirement is to the last known address. And if the last known address is in Hawaii, that's the last known address, right? the notice by publication is not limited. So just because it's a notice that's going to be in a local newspaper, that the law isn't written to say that's only notice to people who are local. It's notice to the world is what it is. So it doesn't matter if you have the last known address, you use that one, you don't get the return receipt, then the default is to do notice by publication, and it's the local newspaper of general circulation. So it works.
This is a question about legal obligation. So someone asks, if an heir or a lender comes to the museum after a time period, do they have a legal obligation to return that item to them?
There were a couple of questions in there, and what they really want to know is how much effort you go to find out the legal heir of an object, and what do you do if someone shows up and says, this is my great, 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 great aunt's piece? What is the institution's responsibility on tracking lineage and tracking the ownership through generations?
So are we talking about an object that you've gone through the process and cleared title to, or are we talking about an object before you've done all that?
So let's say you have a piece, I'm trying to combine all the questions into one.
Yeah.
You have a piece that has been at your institution for generations. You would like to have title of it. The person who was the owner died 100 years ago. What is the level of checking to see who the ownership passed to in a multi-generational family? And on the other side of the coin, if someone comes to the institution and says, I saw that you're claiming, or you have something in the collection that belongs to so-and-so that you happens to be like a loan or founding collection, that how do they have to, again, that goes to the proof side of it. So I think the first part is tracking lineage, and the second part is what do you do?
Yeah, I mean, this is really a sort of a separate body of law.
Yeah.
But you know, if someone is a legal heir, then they're a legal heir. Mm-hmm. And if property has, and this is one of the benefits, going back to a question a little while ago about, you know, what's the point of this to clear title? This is one of the benefits. You're clearing title, so you're cutting off those heirs from, you know, generations down the line. But if you haven't cleared title yet, and someone is a legal heir, then, you know, they have a
just have to prove that they are
ownership interest. As long as that person can establish that lineage, then, and how would they do that? You know, ultimately it would be on that person to avail themselves of the courts to prove that they are the legal heir. The institution doesn't necessarily have a legal obligation to track all that. They don't. But if there's a dispute, then the institution should probably do its best to do its due diligence to either confirm or not confirm the claim. But ultimately, it would be up to the courts.
And the extent to which you would go to contact them is clearly laid out in the legislation. It's that last known address or through the publication based on the type of property that's being disputed, I guess.
Mm-hmm. This is not to say that it might not be beneficial to like do the work to find the heir. I know we have some cases where, I mean, that was our first attempt, is like, well, let's see, I know that this is a known family, let me track through the heirs, and then telling them about this gift that came in, or this one that came in a long time ago, and then, you know, they can become stakeholders in your institution. So I'm not saying that it's not worthwhile to do that work if it is cleanly laid out, but I mean, the purpose of this bill is really for abandoned property where you have no way of finding them. However, it's incredibly complicated. The law does say the last known address of the lender.
Yeah, I think that answers several questions that are still remaining about, searching for them online, etc. So I'm hopeful that that helped clarify some things for those people who are asking those questions. I'm just going to try and squeeze in two more. Here's an interesting one. If an object is given with an income tax deduction, is there any right of return? I don't know if
it's been donated. If it's been donated, it's been donated.
It's been
And
donated.
hopefully you have documentation of that donation.
Yeah, if they're claiming a tax credit on it, then they donated it.
They have donated it.
No longer
There's no title. There should be no title issue. The museum owns it.
Right.
Yeah, if someone's taking a tax credit on something they left at your door, they've donated that because they donated it to a nonprofit.
Yep.
Casey, I'm wondering if you might be able to answer this question. Is there a source for possible sample language to consult when writing these public notices?
Well, for the public notices, that's good. I don't know that. I don't know that our policy brief contained sample advertisements. I would say this is one of those moments where you want to go to Marie Malero, and see if she's got those in the museum law book that you can adapt. Paul, you may have a formula.
Well, the statute has a verbatim paragraph for each of these three.
Ah, good.
That
Okay.
has to be included in addition to some of the specifics.
Okay.
So there's a general paragraph for each that just lays out the notice requirement and says that the institution is claiming the property and whatnot. So that paragraph should be in the notice verbatim, in addition to some of the specifics that we've talked about.
Great.
And it is broken out clearly into those three sections. And
yeah.
This is kind of an abstract question to end on, and I'd like everybody's input. This person is asking if they should be using FIC at all anymore, or if it's on the way out with this new legislation.
Casey can talk more to this than I can. Founding collection numbers can be beneficial when you're trying to establish a timeline.
Yep. What I would do is these days, one of the things that I say is that, small organizations will tell me they'll have like 4 different numbering systems for when they had different volunteer curators. Mm-hmm. The nice thing about it, if you're starting to put things online, if you're using Past Perfect, for example, because there's so many ways to search, you can actually have multiple numbering systems and you don't need to renumber everything because you can just look for powder horns. Right, in all likelihood, you don't have 10,000 powder horns. So what I would say is that FIC is still useful. If you've got nothing, you've got a couple ways to handle this. You could choose, the current year as your FIC number, but there's nothing wrong with FIC because what it does is that it means that as of the date that the record was created, you now have something in place. So you have a couple ways to go. Some places that we have worked with in the past, we told them to take the current year and make all the founding collection, the new founding collections, to make them a 2020 or whatever, give them a 2020 number, but then in a note section, put that they're FIC, right? There's a couple different ways to go about it. It just depends on what you're more comfortable with, but FIC is still useful. The main thing is to start some kind of paperwork process. All it has to have is, these days, if you're using Past Perfect or something like that, is a number, a location, what it is, and a photograph, a digital photograph that you've taken and attached that has the number in the photograph so that it cannot be separated from the object, right? You put a numbering thing right there in the photo. And if you've got all those things, you've got it in the system. You don't need to go any further in terms of cataloging. You do the minimum to get it into your system, and then you can start the clock running. So the big question for some of this stuff is, how do you get the clock started? And so the big way to get it started is to put the most simple kind of inventory record in place, and make sure, of course, that you mark the object in some way with a tag or however your marking system works, so that you can start. The important thing is to be able to start the clock for some of these things.
Yeah, it's really, as Paul mentioned, documentation is your friend. You want to have that documentation in place. And so Casey's saying, start that documentation, because that's when you can say it has been in storage under our care starting on the day that this unique number, it's got to be a unique number that you put with that object. And that's really a way for you to start saying, I'm caring for it as of this date. You may know that it's been there for years, but it's got to be the first of that documentation. You can't base it on memory. So that's really that inventorying process will be hugely helpful.
And if you're a new person, a young staff member coming into some of these places, the other wrinkle that will sometimes show up is objects that have been given numbers, but they're actually loans, and there's nothing in they're not an L number, right? So that you're not sure what you've got there. Like I said, we've run into as many as 4 different numbering systems in some of these organizations. Every time a new volunteer curator came in, they cooked up a new numbering system. And so, that's another can of worms. And all you can do is just start to eat the elephant one bite at a time and figure out, what it is that you need to do. For example, if you're very interested in getting a certain body of things in an exhibit or online, I would start there, try to get those sorted out, and then you can kind of move along from there.
Well, we are at the 1 o'clock hour, and I just want to thank Allie, Paul, and Casey so much for giving us your time and your expertise. I'm really hopeful that folks who are in the audience today found this helpful and have some good advice and next steps to move forward to use this legislation to benefit their collections. Just want to remind you all, this program was recorded. We'll be sending it out to all of you in a follow-up email, so you'll be able to refer back to it, share it with your colleagues, and again, hopefully you find it useful. And with that, I'll say goodbye and thank you all once again. Take care and enjoy the beautiful.
Thank you. It's been a real pleasure.
Thank you,
Good
Paul.
luck, everybody. Good luck on this.
Thanks, everyone. Bye. Bye.